There he is.
Oh, greetings to everybody in the room, everybody who watch us live. My name is Aleš Zalar. I'm a chair of the AGE, and today the advisory group of experts conducts the interviews with candidates for the position of the judge of the Constitutional Court of Ukraine. Now it's time for having an interview with Madam Galamai Olesia. She's the judge of the Commercial Court of Lviv region, and she has been admitted to the competitive selection process by the Council of Judges of Ukraine. I will pass the floor now to the Secretary of the AGE, Mr. Romaniuk, who will be the moderator of the interview. Please, Yaroslav, the floor is yours.
Леся Зіновіна, вітаємо вас.
Дякую.
Вітаємо.
Nice to meet you. Nice to meet all the people who are watching our streaming. So at first I would like to say that all 6 AGE members are present. The chairman Aleš Zalar, he's online, and physically here we have the members of the AGE, Ms. Hanna Sochotska, Ms. Maureen O'Connor, Ms. Natalia Kuznetsova, Ms. Oksana Vasilchenko, and there are AGE deputy members, namely Thomas Griffith, Richard Barrett, Marek Zubik, and Volodymyr Kuzmenko. I am Secretary of AGE, Yaroslav Romaniuk. We worked a lot, accumulated information about yourself, and we're really very grateful for your constructive collaboration with the AGE, for the communication that you supported with the AGE. We gave you questions, you provided the answers. There are a lot of positive informations, and we are really very glad to obtain such positive answers, but there are also some questions we would like to clarify. So the goal of our interview is to give you opportunity to clarify potential doubts about your integrity, about your correspondence to the high moral values that can potentially arise. For this interview, we would like to inform you about the fact that this interview will be recorded and streamed on the AGE and CCU resources. I would like also to draw attention of the members of the AGE and your attention to the fact to limit the use of sensitive data and limited access information on live air. If there is such a necessity, we will restrict live streaming and we will communicate only here without its disclosure. As for our timeline, we would like to draw your attention to the fact that the duration of the interview is approximately 1 hour. We ask you to answer in a concise manner, only on the merit of the questions, and the limit for the response to a question is 3 minutes. There are English-speaking experts in our advisory group. If your level of possession of the knowledge is insufficient, please use the headset with the interpretation facility. So blue light is Ukrainian channel. At the end, you may make a short closing statement up to 5 minutes. And now we're ready to start the interview. And I would ask the reporters to ask the questions prepared in advance. I would start, from your permission. We're happy to see you here, Miss Olesia. I would like to start our interview with the following question. You began your judicial career in the city of Ternopil and served as a judge of the Ternopil Oblast Commercial Court. And you worked on such a position from August 2012 to the February 2016. In the same time, you resided in the city of Lviv. This 5-year term, I don't have any information about the fact that you had some dwelling in Ternopil. The distance from Lviv to Ternopil by road is about 130 kilometers, which takes at least 2 hours by car. So there is such an information. Tell us, please, where have you been living during this time when you performed your functions as judge of the Ternopil Oblast Commercial Court? Please use the mic because we have the interpreters who interpret in English and Ukrainian. So then, I will make some pauses. No, you can just calmly talk because we have simultaneous interpretation, but please raise your voice a bit. There is simultaneous, not consecutive translation. So, serving as a judge of the Ternopil Oblast Commercial Court, just maybe put the mic closer, because do you hear me? And I don't hear you. Now, is it better? Yes. Serving as a judge of the Ternopil Oblast Commercial Court, I constantly lived in the city of Lviv. From time to time, once or twice a week, I lived at my friend Yarina in the village Petriki near the city of Ternopil. Sometimes it happened that I stayed even 3 times a week at her place, but generally once or twice a week. So do I understand you correctly that working constantly in Ternopil as a judge of the Commercial Court of Ternopil Oblast, you only from time to time visited Ternopil? How it can be relevant to the fact that employees should go every day to work? I performed judge functions each day. So at 5 a.m., I woke up at 10 past 6 a.m., I left Lviv by train, went to Ternopil, and at 6:30 p.m., I returned to Lviv because my family lived in Lviv. My daughter went to school for the first year, and I had to serve as a judge and also to be with my family. That's why I worked every day, and then I was in time to go to Lviv. So 4 hours a day. 4 hours a day plus lunch break 1 hour and 8 hours of working time. So 13 hours a day you worked. Yes. So how much time have you been living at your friend's? So it was like once, twice a week, or sometimes you lived at her place for a month? Before the vacation, I could live at her place 3 days, 4 days. because there were a lot of work and I had to do it all. So sometimes I could stay at her place for 3 and 4 days in a row, but it happened only in the period when I wanted to take a vacation. So you didn't have cases when you lived in Ternopil for a month, for 2 months, because you had no possibility to go home to Lviv. And you worked in such a manner for 5 years? No. Since the July 2012 till the February 2016. So 4 years, 3 years and a half. Were not you tired by it? No, I am a very active person. And for me, it's not difficult to change my residential place or to go to different trips. For me, it's not a problem. Clear. Thank you so much for your answer. Now I have another question. In answering the written questions of the advisory group, you stated that in that period, from 2012 to 2017, you were a candidate of the Department of Theory and History of State and Law of the Lviv State University of Internal Affairs. You know, frankly speaking, I express my respect because giving 4 hours of your time to commuting, going forth and backwards, and also conduct scientific research, it merits a lot of respect. And the topic of your dissertation research was custom in law, natural law. Have you finished your studies? It was PhD studies. Yes, I was a candidate. I was a candidate for PhD, so it wasn't studies. I was just a candidate for the period from the August 2012 to August 2017. So it was probably in the same period when you were the judge of the Ternopil Oblast Commercial Court. And tell us, please, why you terminated your work. Well, I haven't stopped working on this dissertation topic. Just when I was a PhD candidate, I managed to bring out a row of the articles. I haven't defended my dissertation, and in future, when I worked in Lviv, I had more time, and I also worked through my PhD dissertation, and in 2021 I repeatedly entered PhD course. So with the same topic, you haven't changed the topic. In further, I changed this topic. Okay, so then let's discuss it later. It will be a separate question. And now you mentioned your articles. You prepared a couple of scientific articles on the issue of your research, and in 2016 you published them. And I have a general question. When you started your PhD research, academicians, they also talk about integrity. So judges have integrity, and academicians, they have academic integrity. Are you aware of this notion? How do you understand it? Yes, I understand it. I understand that the PhD candidate should be integrity related, and using materials of other scientists, this candidate should refer to the sources of the information. So if I understand you correctly, you think that integrity includes the necessity to conduct the research autonomously and to present our own thoughts, to make our own conclusions, but when these thoughts, ideas, and conclusions are grounded, are based on the other researchers due to the intellectual ownership and author's right, we should refer to these works. Is it correct? Yes, this is about academic integrity. Tell us, please, borrowings of the text without referring, is it a violation of academic integrity? Yes. And when you wrote your articles, your works, did you remember about it? Yes. And returning to the article of 2016 in the Lvivska Polytechnica journal, so it was natural law analysis of law and custom, and one specialist analyzed this article. They found out that there is violation of your understanding of academic integrity. So you practically used a manual by Mr. Marchenko. This is the Russian textbook, The Theory of State and Law, and you translated it. So there are a lot of different fragments that are used without referral and reference to these materials in your article. How it happened, can you explain? I found out this information during the interview when I also participated in the selection procedures as a member of High Council of Justice, and there was a question. Before, in the preliminary list of questions, this question was absent, and it was unexpected for me. I couldn't understand how it turned out, because all my publications I mentioned, and I mentioned all the authors, all the references, and after the interview, I addressed my scientific advisor. Because the principle of work with my scientific advisor was in the fact that she provided me consultations. I wrote my articles, she edited them, and she complemented the references, and after she sent it for the publication in the journal. And when I addressed her with the question how this reference wasn't mentioned, so she said, when this article was sent to the editing committee said that according to the requirements, the text should be diminished from 13 pages to 7 pages. As there was no time, she, without informing me, edited this article, and one of the references missed. So I addressed the editing committee to find out why it happened, and editing committee said that yes, these were the requirements, and such situation took place. There is also a letter that I included from this editing committee. In future, it was really very unpleasant for me, and I decided complementarily to address expert establishment. I telephoned a couple of expert institutions to find out whether this borrowed text doesn't exceed the threshold, and the expert establishments, they said that the fastest thing they can do is half a year, because they are very loaded with the work.
Since I couldn't obtain the conclusion in such a short period of time, in order to additionally confirm my absence of my guilt, so to say. I stopped participation. I withdrew my participation for the position of High Qualification Commission. And also, I would like to add and say that my relations with my research manager were very trustful. I never doubted, the actions of her. And I'm more than sure that perhaps it was indeed a kind of error while she was editing the text. Clearly, that for me, it was I could not understand why she did it without letting me know. And I also want to add this research was not used for the dissertation, and when I was discussing the defense of this or submission of this thesis, my research manager tried to explain to me that further on this dissertation or this research must be changed or altered, because she thought that in one of the parts of it there were not sufficient conclusions, so she insisted on it. We had certain misunderstandings, and I did change the topic or the theme of the dissertation. And when you found out from the competition selection commission that you had the issues with the plagiarism, when did you find out? When you're saying that only when I came to the interview, you said that you found out that they were asking you about, borrowing some text without attribution and reference to the original source. When did this happen? When did you have the interview? In September 2022. So 2022. And the conclusion that you just, which expert institution did you refer? The Scientific and Research Center of the Judicial Expertise in the Sphere of the Information Technologies and Intellectual Property, the Ministry of Justice, yes. Tell me, please. The conclusion is dated July 27, 2023. Why didn't you contact the expert in 2022? I did. I called to the expert institution right after the interview, but they informed me that they could not help me in 2 weeks. I see. So you had to wait for a while. Okay, I understand. Let's not dwell more on this. I have one more question. The expert's conclusion of specialists of this institution, has it confirmed that you have the fact of use of the text without citing the source on any fragments of your article? In the conclusion contains information that yes, that there was the use of the source that was not specified in the list, but I asked them whether the fragments of text that mentioned there, that they are in the volume that is acceptable. Dear Olesia, this is a totally different thing. The volume of the borrowed material that does not belong to you, that's a number of quotes, right, that you use. So we can have a digest, as scientists sometimes do. But we speak about another thing, whether you specified that that was plagiarism, if you used material without citing the source or the author it belongs to. We are not speaking about the level of borrowed material. We are speaking about using without citing the source. It was just the comparative analysis, and based on the comparative analysis, so they did not give the answer to the question you were asked during the interview in the body where you competed. Was it the HCJ? Yes. Okay, so the selection commission in the composition of the HCJ, they referred to saying that the used fragments of works of other authors that is not citing the source is plagiarism. And the conclusion of the expert and that I make that conclusion out of your explanation, refers to the level of borrowing the material, and I would say that it's optimal, and that's a rather conditional conclusion, because it's hard to say. No legislation, no pieces of legislation to define the measure of borrowed material. The person who prepares the expert opinion on your work, they are to draw conclusion whether or not your research essay is not only independent, but to contain your own ideas. So I want you to tell us all, do you have in that conclusion of the expert that you have provided the confirmation that you had no plagiarism? In this conclusion, no, it doesn't say. Okay, I see. Thank you. Let's move on. You provide us the documents that you refer to the scientific council, since you have defined in this article the references and use of the sources that belong to the scientists of the aggressor country, and you wanted this article to be deleted, extracted. Yes. And was it the only ground or reason to cancel this scientific result? When submitting dissertation, or is it because you learned about plagiarism? I found out about this back in September 2022 during the interview, and only now I have, at the end of January 2023, after I submitted all the publications to you, since I don't see my fault, I did not steal the ideas, or I cannot be blamed for plagiarism, because I did mention all of the sources, and each article that I have prepared, I sent it to my scientific or research manager to be edited. And during the editing, of course, it's a very unpleasant fact for me that this mistake was made by her. But on your request, per your request, I have provided you all of the articles, because it's very important for me to keep my authority. I am integral, and I always treat responsibly my duties, and also in my other activity, not judicial activity. I try to take such steps and to act in the way that it has to be exercised by the person who has moral values and high spiritual level, and who doesn't, Okay, I completely agree with you, Madam Olesia. I also have very high principles, but, I very often am a scientific manager or research manager, and I have never had in my practice that I would correct the work of my students so much that I would borrow somebody else's text without referring to the source. But nevertheless, as a scientist, I want to say that the author bears responsibility. The author, not the consultant, not the translator, or the one who was editing it. The author is responsible for the content that they submit for publication under their name. Therefore, it's rather strange that your research manager assumed such roles, and now you as a judge, the burden of the responsibility is on your shoulders, and it's not very clear. If I may, I would like to add, please mind that I did submit these publications to you, and at the end of January and the beginning of February, I referred to the scientific institutions to extract these publications, to delete them, because I think that since I did not use them, for submission of dissertation, and since I used Russian sources back then, I just made the decision that it's not politically correct, and I was wishing to eliminate these articles from electronic resources. I see. And which scientific institution did you refer to? Well, Lviv University, yes, of Polytechnic and of Internal Affairs, yes. But you understand that your article was published, it was issued, and as of that moment, it has become accessible for a wide circle. Did you publicly anywhere ask to place official information, maybe in this journal, saying that since the mistakes were made, the author apologizes for so, and the author thinks unethical to use this material in the further actions connected with the future of dissertation? Did you consider this possibility, just to inform the public, especially right after you have the issue in relation to the interview for HCJ? Thank you for an interesting suggestion. I think I will do that. Thank you. Okay. Then I have another question, and this question is connected with the declarations. In your declaration for 2015, published on the website of the National Agency for the Prevention of Corruption, you mentioned a 74 square meters residential building in Lviv, which belonged to you and your family members on the right of use. The date of acquisition of this right of use for you and your daughter is given as of January the 1st, 2014, while for your husband, it is July 26, 1988. At the same time, your judicial file contains copies of your 2014 and 2015 declarations, which were submitted in paper form. In these declarations, you did not mention any residential building in Lviv. Thank you for your question. So to make it clear, in 2014, louder please, Olesia. We can't hear you. Okay, so during 2014, my family and I resided in the house of my mother-in-law, and the place of residence in the annual declaration for 2014 and 2015, in the line place of residence, I mentioned this house. I entered data on it. At the end of 2014, at the end of the reporting period, my husband and I, for a few weeks, moved to my apartment, a small apartment that was located on Doroshenko Street, and there we lived by the end of the reporting period. That's why in the declaration for 2014, since I had the explanation of the commission that you have to specify the place of residence for the time of the 31st of January 2014, I did specify this apartment, Doroshenko 13th Street apartment. In the next declaration for 2015, I made a mistake, yes. In the electronic declaration, I have reflected the right of use of the house and the place of residence in my mother-in-law, but in the annual paper document, I did not do it, so I think it's a technical error. So you have different information in two declarations for the same period, right? So in one of the declarations, the electronic one, you specify the address of the house on the right of use that belongs to your mother-in-law. And in the paper form, You did not specify this right of use, right? Yes, okay, I shall repeat myself. Let's speak about 2015. 2014, clear. In 2014, on December the 31st, you lived in Lviv, yes, in your house, yes. And then we speak about two declarations. 2014, we accept your explanation. Okay, you living on Doroshenko Street. But what about 2015? Where did you reside? In the house of your mother-in-law, or did you continue living in your apartment on at Doroshenko Street? No, during 2015 and by the end of the reporting period, we lived in my mother's-in-law apartment, and in the annual declaration for 2015, both in the line place of residence, I displayed this property of my mother-in-law, and I also showed the right of use of that object that we used during that year. But in the annual paper declaration, that back then was not mandatory to be filled out, but I did not duplicate. It was technical error. I forgot to duplicate. Okay, now clear. Thank you. In your declaration for 2019, in the Unified State Register of Declarations, you indicate an apartment in Lviv with an area of 74 square meters, which belonged to your husband by right of use. And the question is, why wasn't this apartment declared by you sooner in 2013 and 2018? What apartment is this? Please explain. Thank you for your question. This apartment, it's the same building that belongs on the right of use to my mother-in-law. First, this was the house that had 74 square meters. On the first floor, the relatives live, and on the second floor, mother-in-law together with her husband live, and us. We, for a while, used their house as well, but further on, when in 2019 I filled out the declaration, my mother-in-law informed me that this house is that it has been entered into register not as a house but as apartment. So correspondingly, in the previous declaration, it's the same object, the same facility. This private house is the same facility, and on the basis of which document the residential building that is not an apartment in the building, because you as a judge, you do understand that some questions of the civil law, right? So the property right can arise either for some apartment in the block of flats, like in the house, or it's a separate residential building that has a land lot. So how did it happen that it was re-recorded, like re-registered? How did the house turn into apartment? Yes, of course, I was curious, and I asked my mother-in-law, and she did not want to tell me this information because when the declarations filled out, it was March 2022, I was already divorced. So she did not give me any explanations or rightful documents. She didn't provide it to me. So I filled it out from her words as she informed, and I declared it in that way. So you declared the right of use by your husband for this apartment with total area of 74 square meters that belonged on the right of use to your mother-in-law, right? Yes. Yeah. Another thing we want to clarify. It's the question referring to dates. At first, you said that your husband gained the right of use of this apartment in 1988. That's how you specified it. At least it says in declaration per 2015. And in declaration per 2019, the date of acquisition of the right of use is is the June the 14th, 1998.
So, what is the link between it? In 2015, my mother-in-law didn't provide me any documents. I received data just from her and I put them into the declaration. From the declaration for 2019, she presented for me another date. So she informed me. Okay, so this is related to the fact that maybe you had bad relations with your mother-in-law. In the declaration for 2020, you indicate another residential building in the village of Uzlove, Lviv region, with the area of 179.5 square meters. You stated the date of acquisition of the right of use as 18th of May 2001. How can it be? Why did you not register this house before 2020, if, as you stated, the right of use arose in May 2001? Now I will explain you. So, the explanation about the acquisition of the right of use I didn't have. That's why the date for the acquisition of the right of use that I declared stated the acquisition of the right of use by my family, by my father, in May 2001. That's why it was a technical error. And as I started to use this residential building at the end of 2019, I registered it. But why you stated that the right of use arose for you in May 2001? It is a technical error. So you have been using this premises, this building, since 2019? Yes, since 2019, since the end of 2019, I stated the right of use. And I stated this house because this was the house of my father in village of Uzlove. But I resided in the building in the village of Skneve. That is of the ownership of my mother. And when I divorced with my husband, from time to time I used the residential building from my father. That's why I decided to announce it. And the house of your mother, have you showed it in the declaration? Yes, I have showed it. I have no questions as for declaration. I would pass the floor to Mr. Alish. Mr. Alish, the floor is yours. Thank you.
Thank you, and I will continue asking questions with respect to the candidates' declarations, because there are so many unsettled issues. Madam Galamai, in your 2017 and 2018 declarations, you declare an apartment in Zhytomyr which was used by your husband. Could you explain why you cannot provide information on the date of the acquisition, the area, and the value of this property?
During filling in the declaration for 2017 and 2018 years, I addressed and asked my husband and asked him to provide me such an information. He refused to provide me with such a data. That's why in the declaration I filled in that the member of my family hasn't presented me such an information, but I informed that my husband has worked and works within correspondent bodies, and maybe it is related to his professional activity. I would like also to add that I tried to find out the information. I looked through the register of declarations, but these data are closed because there is no access to the declaration of such category of servants. They are closed for public.
So you asked your husband to provide this information, but he refused to do so.
Так.
Yes.
You were divorced from him at that time or not?
Ні.
No, we were not divorced in this period of time. The motives why he didn't reveal me this information, for me, the only explanation I can find out that maybe it was related to his professional activity.
What kind of professional activity?
He works in the security service of Ukraine.
Okay, I understand. In your annual declaration for 2019, you provided information about your husband's income only partially, because you did not indicate the amount of funds he received from the military unit. Why this? Can you explain this?
Thank you for your question. During 2019, my husband worked for a military union in Zhytomyr city, and after he was transferred to the military unit of the city of Lviv. In March 2020, when I had to fill in the declaration, I already was divorced with my husband, but I addressed him and asked him about his profits and revenue. He informed me about his revenues in the military unit in Zhytomyr, and I reflected it in my declaration. He rejected to give me information about the Lviv military unit revenues, and I presented it in my declaration that there is a rejection from family member.
I have a very general question to you with respect to all these, you named them technical errors with the declarations. Are you aware of the provisions of the Code of Judicial Ethics and the provisions of the Bangalore Principles of Judicial Conduct, which require a judge to take reasonable steps to be aware of the property interests of his or her family members?
Так.
Yes, sure.
Do you consider that you complied with these requirements in these situations?
Thank you for your question. Yes, I tried to find out the information from my husband. He rejected to reveal me such an information. I didn't have access to his declaration. When I even looked through the register of declaration, these data were not available. I couldn't find out this information about his revenues in other way. So I asked him, I asked his parents, and I asked his parents to ask my husband about this information. My husband didn't reveal this information to his parents also, and I reflected only those data I was aware of, and I provided all the activities to find out this information.
Okay, thank you.
Дякую.
You said earlier that as of the end of 2013, you were residing in a separate residential room at 13 Doroshenko Street in Lviv. Did you live there with your family?
Yes, I lived there together with my family for a couple of weeks. At the end of the reporting period.
How old was your daughter at that time?
7 years. She was 7 years old.
These premises, were they suitable for living?
Так.
Yes, it was suitable. There were all communications, heating facility, gas, water supply.
Bathroom also?
Так, він був
Yes, there was a separate bathroom with a kind of wall. Can I?
Да.
Please.
Thank you. So, when there was opportunity, when I took vacation or leave, we wanted to live separately as a young family, even if it was small flat or apartment, but we would like to use this opportunity to live separately, and we used what we could.
In 2021, you acquired a one-room apartment in Lviv of 45.7 square meters area with the value of 965,000 Ukrainian hryvnias. Now, how can you explain sources of these funds?
Sources of these funds to buy this apartment were my savings from my retribution in the period from 2005 to 2015, and also revenues from alienation of immobile property, and also my retribution that I saved also.
Kind of form did you make payments for purchasing this apartment? Was it paid in cash?
коли
When we made a contract at notary office, I gave cash in the presence of notary, and what did they do after? I don't know.
Consider that you complied with the requirements of the law by paying for the apartment you purchased in cash. Is it according to the law?
обов'язок так.
Yes, the duty to do it is on the person who buys, not on person who buys it, but on person who sells it. So the seller, I don't know how the seller did it. Maybe he made it the bank transfer. Well, it's not about it. It's about how to conduct the payments under the notary attestment from seller to buyer. Yeah, it should be done cashless. It should be cashless operation. And in your case, it was cash operation, but the notary said it must be cash, and I don't know how they did it after. Notary informed me that I should give the fund in cash, so the notary was present during this operation. So whether they use a depository account of the notary or I don't know. Ms. Olesia, so you are a judge and you understand that if it is written that it should be done in cashless form, it means that you should or input it to the depository account of the notary or to the account of the seller or in other way. But you can't give it in cash even to the notary if there must be cashless operation. So this is the question. Yes, I think that in further they converted it into the cashless form. I can't say it 100% because I do not have any relations with the seller. And have you received any document about the payment done? So how have you received the document that you have paid this sum 965,000 hryvnias? Which document you obtained from the notary that you have paid it? I even don't remember. So just imagine, you pay, well, almost 1 million Ukrainian hryvnias in cash, from hand to hand. There is a controversial question. You're a judge. You don't remember whether you obtained any document. Maybe it was a provision of the contract that the payment was done with the presence of notary. Yes, it was written in the contract, it seems. So it seems or it was done. Maybe you can look at it. You have a lot of documents with you. No, it's not mentioned in the contract, but I didn't put into doubt. Let's imagine the situation. I am, as a lawyer, can say, your seller comes and says, pay me the sum of money. Your actions. I understand what you are talking about. I trusted the person. And yeah, these were for individual entrepreneurs, these restrictions. Yes, okay. So please think it for the next time. Thank you so much. Thank you for your remark. Okay.
According to the website of the High Qualification Commission of Judges, you are currently also participating in the competition for the position of an appellate judge. Is it right?
Так.
Yes, it is right.
This simultaneous participation in the competition for the position of a judge of the Constitutional Court and judge of the Commercial Court of Appeal correlate with one another. What is in fact your priority here?
Thank you for a question. My priority is to be involved into the Constitutional Court of Ukraine, to have possibility to formulate official doctrine, provide constitutional freedoms and rights of civilians and citizens. But I would like to say that Oliver Holmes, the US Supreme Court judge, who said, the most important thing is not when we stand, but in which direction we go. And if I have professional experience, skills, and I have big wish to be useful and to work, then I think that I need to implement my experience. And when we talk about the Court of Appeal, I would like also to implement new judiciary practice in the Court of Appeal. Moreover, what I would like to add about my motivation,
And it is primarily based on me wanting to be useful, of use. And if we speak about my intention to become the judge of the Constitutional Court of Ukraine, this wish, this desire I had when I changed the topic of my thesis research and began writing the thesis for the topic of digitalization of the system of justice. I consider this topic through the prism of the legal positions of the Constitutional Court of Ukraine. And for me, it has become a rather interesting material to study the legal position of the Constitutional Court. I went deeper into the constitutional law of Ukraine, and even one of the chapters of my dissertation will be related to the electronic activity. So sorry. Okay, let's stick to the regulation. Okay, we understand. So the priority is the constitution. Okay, in 2022, the competition was announced. In 2023, the Constitutional Court, and they did not take place because of the amendments to the legislation. Did you submit for participation for these competitions? Only for the competition as of February the 3rd, 2023, that was before this competition. After that, you have also submitted for the HCJ competition and now in the Courts of Appeal. So if the priority is the Constitutional Court, then why do you also submit or want to participate in others? Okay, the clarification. First, my wish was to try me in the HCJ, but then since the competition was announced for the Constitutional Court of Ukraine, I wanted to, and I wanted to try, and so I applied for the participation. So you develop in this direction now, yes. And if I may, a few more minutes to add. As for the Courts of Appeal, I study legislation, and 6 months ago, I gave the amendment for the Economic Procedural Law of Ukraine for the Committee of the Verkhovna Rada on Legal Policy. So was it adopted? Yes, the Supreme Court seconded that. And the Council of Judges of Ukraine is still finalizing it. It refers to the proceeding by the Courts of Appeal, the term for challenging. So, dear Mr. Chair, do you have any questions? Do other members have questions? Olesia, I had to say it right in the beginning, but I see that you brought many materials with you. In accordance with the methodology of assessment, we do not take the materials or documents that you submit now into consideration, even though nothing precluded you from providing them in timely manner for us to be able to study it, and also those documents that we have requested you to provide, but you on some reason did not provide it. We can make an exception, but only if you name some reason, some significant reason. Thank you. All documents I thought that had to be part of it, I already provided them. If there is an inquiry on any additional docs, I can do that. No, we don't. If there are no more questions, we are ready to finish the interview with you. But before we announce it being over, we are giving you the chance to give us the concluding remarks. You have 5 minutes. Thank you for such an opportunity. Primarily, I would like to express gratitude to all of you for your attention and your time dedicated to me, for such a well-grounded interview, for also noticing my mistakes that I made in the declaration. If I may, I want to go back to the declaration and mention that technical error on the date of gaining acquisition of the right of use instead of the date of the acquisition of the right by the owner. I specified the date of acquisition by the owner instead of the right of use. So therefore, that's why this question is there, why I didn't mention certain objects of property before that. But at the end of the 2024, the Commission has given the explanation on this line of declaration, and I have corrected all of these flaws in other declarations. And as for me wanting to hold the position of the judge of the Constitutional Court of Ukraine, I stick to the principle that if the person has the potential, if they want to dedicate themselves and to be of use, they are to use such a right. And it's, frankly speaking, a joy for me that I can be present right now and to participate in this competition that takes place in being so open for society and transparent. This is a big step on our way to the European standards and European values. I felt like mentioning this and say that I'm very happy about this. And I want to wish us all peace, kindness, and victory. Thank you. Thank you, Olesia Zinovievna, for supporting the communication with the advisory group of experts. Thank you for your answers. And now I announce the completion of the interview with the candidate for the position of the Constitutional Court of Ukraine, Galamai Olesia Zinovievna. Thank you.